I want to thank everybody for coming upstairs for lunch. If I could interrupt your lunch for just a moment. We're going to move on to our lunch speaker, and we are very lucky and honored to have Congressman Scott Garrett from New Jersey here with us. Again, there's a more extensive bio that's been handed out, but this is not the first Cato event that Congressman Garrett has spoken at, and in fact, I feel like we might be going to him too often, but that's only because it's hard to find a congressman who consistently, I think, is on the right side of so many issues as Scott Garrett. So it's a real pleasure to have him here over to Cato, and I do appreciate him coming across town. So I want to turn it over to the congressman who's going to speak for a little bit and take a few questions. Thank you.
And there you go. And thank you for the introduction. Thank you for allowing me to be here and say a few words. Thank you for allowing me to interrupt your lunch. I see there's a lot more food out there, so feel free to get up, get more, enjoy your lunch. So today's today's gathering, what have you, I understand is entitled Dodd-Frank's third anniversary, right? Has it all been worth it? And I guess, to answer that question, which is what I'm here for today, is it all depends on who you ask the question to. If you ask that question to some of the many newly hired professionals in compliance, and I know a number of them now up on Wall Street, I would say they would say it's a resounding yes. If you asked all the lobbyists here in town, who are now making, well, they were always making a lot of money, but now they're even making more money, hand over fist because of this, I would say that they would answer yes. If you ask any of the Beltway bureaucrats who have had their budgets, their power, their authority exceedingly increased exponentially, I think they would say yes as well. If you talk to anybody in my profession, that is trial attorneys, or if you talk to unions, they would probably say yes as well. And of course, if you asked folks over at Fannie Mae and Freddie Mac who've been able to continue to crowd out private investment in the housing market and basically further entrench their monopolization on the secondary mortgage market, they would answer yes as well. You can go on further if you ask the too big to fail banks around this country, especially my neck of the woods, who are still happy with the implicit backing that is locked into Dodd-Frank, the answer would be yes. And of course, if you ask Chairman Gensler, who is trying to exploit the laws by fundamentally altering a limiting provision into one that enables him to regulate the entire global swaps markets, albeit that some of it pushed back by some of us, he would answer yes as well. So, in answering that question, I guess there's a resounding yes, if you ask the right people. However, on the other side of the equation, I would think there are some folks here who might be saying no. If you ask a small group of people from the back at home, from the community banks, they may say no. If you talk to some of the folks from the credit unions, they may say no. If you asked any of the job creators, the innovators, the risk takers all across this country, the entrepreneurs, they would probably say no. And of course, if you go back home and ask the taxpayers, who now explicitly support large, too big to fail banks, they would say no. If you asked right around this neck of the woods, the terribly overworked D.C. District Court, who has had to keep up with striking down portions of Dodd-Frank and the regulations, they would say no. And of course, again, if you ask the homeowners, the consumers, small businessmen and women who are struggling right now basically to get any access to credit in the credit markets, their answer would be no. And finally, if you ask the founding fathers of this country, they would say no. Now, I realize you can't ask the founding fathers, they're all dead, but they have given us the Constitution, and that is very clearly indicate that they would say no. So if you know my record, and the fact that I'm here, I guess some of you do, I voted against Dodd-Frank because it had failed to address one of the most fundamental causes of the financial crisis, and one which we are now looking at last week in committee hearing. I appreciate Mark attending that for an all-day event, and which we'll be doing marking up later on. But it continued, though, to allow for government intervention into the private sector and continue with the institution of policies that are basically killing jobs. But there's another what do you want to say, more fundamental reason why I oppose Dodd-Frank. And I think surprisingly, well, the reason for that is one of the main reasons actually why I went to Congress in the first place back in '02, which was, and why I later started the Constitution Caucus, is because Dodd-Frank is fundamentally unconstitutional. And there is, as you probably know, a lawsuit that is right now challenging the constitutionality of Dodd-Frank, and it really, I guess with all the other scandals that are going on around town, has gotten surprisingly little attention by the media or by the folks downtown who pay attention to these things. And that's why I just want to talk about that a little bit today. When you talk about the Constitution and the Founding Fathers, one of the philosophical foundations of our Constitution is what? It's the protection of individual rights, individual liberty, and to do so how? Through a limited government. And as a result, our Constitution establishes, as it does, a government that is supposed to be based upon restraint. And it does so how? It does so by enumerating a few specific defined powers, which our Congress continuously violates. It does so by dividing the powers of responsibilities between the branches and establishing a so-called checks and balances. But with Dodd-Frank, rather than establishing a regulatory regime that is consistent with these constitutional principles, Dodd-Frank is, I would say, the great exception to the Constitution. Dodd-Frank creates not one, but as you've discussed in previous panels, two agencies that are granted essentially unlimited power to define and regulate basically every conceivable financial transaction in the country, and it is accountable to no one. And I'll digress here. If you watched the hearing that we had 2 or 3 weeks ago, when you had some folks over from CFPB asking them as far as their ability to be accountable to anybody, they said, no, we are not accountable to anyone. So the two agencies that we're talking about is that one, the Consumer Financial Protection Bureau, and the second one, of course, is EPSOC. Put them together, they are basically the judge, the jury, and unfortunately the executioner, if you will, of the economy of this country. So let's take a minute then just to talk about the CFPB. As I said, we just had some folks from there, and COO, I guess it was, and that was the last question I put to him. Are you accountable to anyone? I asked him the question repeatedly. He basically dodged it, but his last breath was, no, we're not. This agency really could not have gotten off the ground without what it did do, which was to violate the Constitution. I, of course, refer to the fact that the unconstitutional appointment of its director, Richard Cordray, during a recess appointment. And unfortunately, last week, Harry Reid in the Senate held over, despite a 200-year Senate tradition, held hostage and by default wound up pulling the so-called nuclear option, if not directly, but you might say indirectly, and forcing, you might say, the minority party to approve the president's outstanding executive appointments, regardless of the concerns that the minority held. Now, some of us wish that the minority would have held them a little more firmly and stood up to that pressure, but that is not the case as far as the Senate. That's why you have the House, at least in these areas. So the president's actions on the illegitimate recess appointment of Mr. Cordray did what? It basically erased the advice and consent clause from the appointments clause of the Constitution. And by doing this, it imperils the legislative checks and balance that the founders intended in the Constitution. And why did they put those in the Constitution? Because they were fearful of tyranny. Unless we are able to have a check and a balance on power down the street in the White House, they would have unlimited power in the White House, and that's what you see here with CFPB. Now, we've had the appointment since then, so some people now step back and say, well, that is old news, because it's not a commissioner type arrangement. He's able now to basically ratify all of his appointments that he made prior to him getting there, and so they say the issue of unconstitutional muster is of no significance anymore. But let me point this out. It's worse than that because if we delve into Dodd-Frank just to see what their mission is, it goes so far. CFP mission is to prevent practices, this is what it says, that is empowered to define as, quote, unfair, deceptive, or abusive. And it does that. It has that directive of law with the limitless grant of authority with absolutely no checks whatsoever on the CFPB. And if you step back, and again, if you read some of the writings of our founding fathers, if you read some of the writings of James Madison, and I think it's 57, but I'm not sure, he says, when he called Congress's most complete and effectual weapon is, anybody know that? The power of the purse. But with the CFPB, by funding it as it does, not through Congress and not through the appropriation powers, it takes that away from that. And of course, it does it through the Federal Reserve. Furthermore, the CFPB director is exempt from the executive branch. So he's on the one hand, he's exempt from us over the legislator, but he's also exempt from the executive and the president. How so? Because the director is appointed by the president for a 5-year term. But after the 5-year term is up, he can stay on how long? Basically indefinitely, if no successor is ever confirmed. And if you just see how this process went through, if we're so lucky to have a Republican president next time around, if we're so lucky to have a Republican Senate, I'm sure that the Democrat minority will probably acquiesce, just like the Republican minority acquiesced this time, to allow the next confirmation to go through. I'm not holding my breath on that, but if that does not occur, then that means after 5 years, and the Senate can't confirm a new director, we will have Richard Cordray on indefinitely. How can he be removed? Well, the director can only be removed under strict, limited circumstances and not for policy reason, which basically means that if the next president decides that he is not conducting the policies as he would like to, doesn't matter, he can do it. Additionally, so now we have the legislative, now we have the executive, and just back down the street this way, the judicial review is limited because of special deference is given to CFPB legal interpretations as well. So all 3 branches of government are basically removed from degree of oversight from the CFPB. And finally, the CFPB is headed by a singular regulator who basically, and I was just reading through it again the other day, has essentially unlimited power. So he's not accountable legislative, not accountable executive, he's not accountable to the judicial. Now, I want to stress this point is not simply an academic point. We could probably go through a whole list of how this violation of the exercise of a constitutional authority of unrestrained has implications across the board. Let me just give a practical one, and that is in the area of salaries. Of the almost 1,000 employees that they have 958 employees as of a little bit ago. 577 of those employees over there, that's 60% of the entire staff, they make over $100,000. 20% of them make over a good salary of $150,000. 5% of them make a salary of over $200,000. Now, you might think, and a lot of people push back on this, well, there's a reason why there are such high salaries over at the CFPB. It's because of the talent that they need for all the important jobs that they're doing. Well, one thing you should do, it is summertime, is just to check in to see how much they're paying for interns over at the CFPB. Interns' annualized salaries are probably the same as Cato, $40,000 a year for interns. So it's a great place. Unfortunately, $40,000 is more than a lot of members of Congress pay their full-time staff for the entire year. So we might be surprised by this, but we really shouldn't be surprised by this. If you consider all the unconstitutionality of it, if you consider the immense power and the immense mandate that has been given to this, when you consider the fact that they know that no one is really watching, and even if anyone is watching, they know that there is no accountability, they know that there is no consequences. When we had the director from assistant director up, assistant director, I guess, up there at one point in time, we were asking about the salaries, just as one particular point. He had no idea what was going on within their own watch. I guess they basically feel justified in doing just about whatever they want to do. So this is what we can result from a lack of accountability, and this is really what should frighten all of us. But there's still more. Move away from the CFPB, move over to FSOC, which I think you discussed about. That's Title I of Dodd-Frank. That creates the Financial Services Stability Oversight Council. And what is that supposed to do? That's supposed to serve as a systemic regulator. Now, go back in time, about 2.5 or 3 years, I guess, when Dodd-Frank was initially going through committee. How many people here, just like to know my audience, was tuning into any of the committee hearings that we were having? Okay, good. Only one person in the room. Everybody else was out there making a living or having fun. So if you tuned in that time, you may recall then, gentlemen, that the question came up repeatedly to the many panels who were there as proponents of Dodd-Frank who said we need a systemic regulator for systemic risk. We asked them, and I asked them this question, I remember Geithner was there, can you define to us what a systemic regulator is? And not one of them could do so. Now we have a law that basically says we have a systemic regulator, and it's the FSOC. And what is its charge to do? Is preventing too big to fail and preventing all future bank bailouts. And that therefore means we are never going to ever again have a crisis like we had back in '08 because of the passage of Dodd-Frank. With this mandate, the power of the FSOC, just like the CFPB, cannot be overstated. What do they have the authority to do? They have the statutory ability to promulgate its own rules and regulations, as well as authority to determine which non-bank financial institutions would be subject to seizure. And with all this power, the chair, by cabinet level position, is chaired by someone that the president gets to appoint. What's the significance of that? The significance of that is the politicalization of this process. Additionally, FSOC is empowered with the ability to control the activities of any, note the word any, financial institution with simply a 2/3 vote of its membership. Now, you hear all that, you consider all the immense power that this entity has, and you might sit there as strong constitutionalists and say, well, isn't that unconstitutional? Now, if you think that, you're not alone. Other people thought it was too. People who also thought it was potentially unconstitutional as well were the drafters of the bill itself, the proponents of the legislation. And how do we know that? We know that by digging deeper into the bill. We know that they specifically said that the courts are not authorized to review and rule on whether or not the FSOC has been correctly interpreted the provisions of Dodd-Frank. So basically, they've just pushed the courts out of being able to determine any of the constitutionality of it. Step back even further and you say, look at all that Congress has tried to do over the years, over the 225 years of our history. Who knew that it was that easy to simply push the Constitution aside? All you had to do was pass a bill like Dodd-Frank and say, Supreme Court or the courts, you just simply have no authority in this area, and we can get to do what we want to do without any oversight by any other branches. Move on from that to the issue of liquidation authority. We see that the problems with this entity do not end there. Under Title II of Dodd-Frank, it deals with something called orderly liquidation. Under this title, the government can decide, again, if a financial company, anyone in the country under this title, can decide if they are basically in danger of default, and if they were to default, whether that would be a systemic risk to the overall economy. It goes back to the initial question that we had for the members of the panels that we had when Dodd-Frank were coming through. What is the systemic risk? They couldn't define it now. Now they're going to be able to define it to such an extent that they can actually look at one financial institution and say that you are going to pose unilaterally a systemic risk to the country, and therefore we have authority to rein you in or close you down. How do you go about doing that? Well, it's very simple, actually. If the Treasury Department answers yes to both of those questions, it can basically do what? Replace the entire 200-plus year history of the bankruptcy code in this country and put it into receivership. Now, this type of power, of course, is unprecedented. It grants an immense, unlimited power, if you will, unquestioned power to a handful of, not politicians, mind you, but basically unelected bureaucrats. And it does what we've been accusing this administration has been doing for the last 4 or 5 years, and that is allowing them to pick winners and losers among the liquidated companies and the investors behind them as well. Now, once they do this, or once they pick you out and say that you are going to be a systemic risk to the economy if you default, a couple things happen. An order is issued. That company then has a full 24 hours to convince a federal judge to say, stop it. 24 hours to be able to stop this entire process is a mind-boggling period of time, short period of time to do it, but that's all they have, is 24 hours. If the company fails to meet that test, and I would say that is almost an impossible standard, then the government basically wins by default. And the government then can begin the process of liquidation, even if your company and even if the company that you're invested in continues to appeal the process. So they do it, 24 hours is over, they begin to liquidate, start selling things off, you're in court appealing it, meanwhile all the assets are being lost. Again, go back as far as, don't you think that some of this is unconstitutional? Again, the proponents of it thought so as well. So what do? They also put another provision there, prohibits the courts from reviewing whether the Treasury's decision was constitutional or not, or whether it was even necessary to protect financial stability of the country. So while Treasury is determining the soundness of the institution, looking at your company, seeing whether it's sound or not, whether it's going to have a impact upon the economy, Dodd-Frank then prohibits the company, your company, from disclosing the fact that the federal government, the Treasury, is looking at you. So in other words, they come in, they're telling you they're looking at you, you want to let that information out to the public, they tell you basically no, you can't tell anybody else, you can't be going to the court at this period of time, you're closed down. Now there'll be some people who think that the 24-hour period of time that I mentioned before is enough time to challenge a government's unilateral and arbitrary decision by the country. I would disagree. But if you are not this person, the authority in Dodd-Frank must be seen then by all of us as a unilateral, excessive, unilateral attack on not only the company, but also the investors in that company as well. It is a war on free markets in this country. Looking at all this in a 30,000-foot level, it's astounding to think that in many ways Dodd-Frank is unconstitutional, and it is bad enough when Congress acts in a way that violates a single part of our Constitution, but it is infinitely worse when Congress works to virtually eliminate all systems of checks and balances between all three branches of government, and it does so all in one swell swoop, that is Dodd-Frank. It is even more frightening, and I'm sure that it is constitutional violations that we just set out here. I think I went through 4 different constitutional violations just in these 15 or 20 minutes that I've been talking. The problem is there are even more in it as well. It is even more frightening when you go back again to one of my more favorite quotes from James Madison, when he says that a bill is bad not only because or a law is bad not only when it's unconstitutional, of course, but also when, you probably know this quote, when it's so voluminous that it cannot be read or so inherent that they cannot be understood. For those of you, I guess there was just one in the room who was watching this hearing. For the rest of you who didn't tune this in, you may know that there was multiple hearings both in the House and the Senate and in the conference when this was always going down. I was in the House when this was occurring. I was also placed on the conference that went on for a couple weeks as well. As you probably know, many of these provisions that we've talked about are provisions that were added at the very end of the process. Some of the provisions that we didn't talk about here, that goes back to the Gensler provisions with regard to Title VII and derivatives and that sort of thing, were actually added to the bill at around 3 o'clock in the morning, just before the bill came down. From any point of view that you look at it, this is a violation of our rights, of our liberties, and for that reason, I hope that 3 years from now, we will not be having a similar lunch marking the 6th anniversary of Dodd-Frank. And with that, I thank you very much for your kind attention this afternoon.